Hello again, and welcome to our podcast series on NATO procurement. Today I have a very special treat for you. I have Mr. Philip Chulick, who's NATO's Principal Contracting Officer, and he will discuss things like DOEs, ICBs, and the BOA.
American companies doing business with the agency should find the environment fairly comfortable. To begin with, although both NATO official languages, English and French, are widely spoken within the agency, the working language is English, and all documents are issued in English. All contracts are firm fixed price. American firms may bid in US dollars, and they will be paid in US dollars. Almost all firms that have done business with the US government should have little trouble understanding the terms and conditions of an agency contract. American firms should also understand, however, that doing business with the agency is outside of the U.S. legal framework, so that there is no recourse to the U.S. court system in the case of disputes. The good news, however, is that there is no recourse to any national judicial system, and disputes are handled by binding arbitration. Firms doing business with the agency are exempt from taxes and duties under NATO contracts. U.S. firms are still subject to federal law concerning export controls and technology transfer. Of course, local federal laws are always applying. Finally, U.S. firms should understand that they are not dealing with the agency without any net. The U.S. mission to NATO, among many other things, represents the interest of American businesses and are there to ensure that American firms are treated fairly and that the rules are followed. The NATO member nations have established NATO-wide rules for procurement. For large value procurements, international competitive bidding, or ICB rules are used. ICB requires the submission of sealed bids containing a price quotation and technical proposal. The standard selection criterion is for the lowest price, technically compliant bid to be awarded the contract. For more complex acquisitions, best value source selection procedures may be used. The ICB process may take between 9 and 12 months to reach award from the time it is issued. It should be noted that participation in an ICB is restricted to those firms that have been nominated by their national delegation to NATO and which have been endorsed by a Declaration of Eligibility. For U.S. firms, this declaration is issued by the U.S. mission to NATO. For less complex procurement, primarily of COTS products and standard services, a competition amongst holders of a basic ordering agreement, or BOA, may be conducted. The BOA program consists of a series of framework contracts with commercial vendors, now around 800 firms from all NATO countries. Firms applying for the admittance to the BOA program identify their products and services and capabilities from a list provided in the application package. When registered, these products, services, and capabilities are entered into a database, and when the agency has a requirement, the database is consulted, and firms offering the product, service, or capability are contacted and offered an opportunity to submit a bid against the requirement. BOA opportunities are not publicly advertised, but are listed on our website, and even if not contacted, a BOA holder could submit a bid. Like the ICB, a Declaration of Eligibility is required, but this is submitted as part of the application package. BOAs are almost always awarded on lowest price, technically compliant basis. And awards under a BOA are considerably shorter, taking perhaps 6 to 9 weeks instead of the 9 to 12 months. I personally would recommend registering for a BOA as the first step for any business interested in doing business with the agency. I would like to point out that the ICB and the BOA procedures are not mutually exclusive, and BOA holders can bid on ICBs by following the Declaration of Eligibility criteria. The use of ICB and BOAs are expected to continue at approximately the same level as in the past, so I don't see any particular change in the dynamics there. The agency will announce to the nations that an ICB will be conducted at least 28 days before the solicitation documents are released. Nations are responsible for finding, screening, and certifying nominating these companies. In the U.S., such announcements will appear in the Department of Commerce fedbizops.gov with instructions on how to apply. Therefore, to participate in the NATO International Competitive Bidding, U.S. firms must be approved by the U.S. Department of Commerce in accordance with BIS 4023P instructions. Firms are approved for NATO ICB on a facility-by-facility basis. In other words, Company X in Texas cannot be nominated and submit a bid from Company X division in Massachusetts. The NATO ICB application is a one-time application. The application requires supporting documentation in the form of a company resume indicating contracts completed as a prime contractor, and 2, an annual report or set of financial documents indicating compilation review or audit by an independent CPA. After approval of your one-time NATO ICB application, the Department of Commerce will then issue a DOE for that project. A DOE is used by the U.S. mission to NATO to nominate an approved firm to the bidders list for a particular NATO ICB project. If a company is interested in signing a BOA with the NCI Agency, it should email the BOA program coordinator at boa@ncia.nato.int and request a BOA information packet. You will receive a detailed file containing all background information, templates, and instructions for the application process. Registration will be done electronically. In parallel, the companies have to request their authorities' U.S. delegation to provide a Declaration of Eligibility. As previously mentioned, the original declaration issued for the BOA is valid for 2 years for all subsequent bids made using that BOA agreement. In their applications, firms must demonstrate their ability to provide commercial off-the-shelf products for military application, including the ability for the equipment to be supported and maintained post-delivery and within the specified warranty period. Firms will need to provide their pricing structure and to demonstrate that NATO is being offered most preferred customer terms and that NATO will always be offered and supplied with the most up-to-date products. Once firms have successfully registered, they will be automatically notified of appropriate opportunities according to the categories of goods and services for which they are registered. The opportunities that you will be alerted to will depend on the capabilities that you have declared. If you qualify for the criteria, you will be automatically notified. However, companies are encouraged to check the agency website periodically, as any company holding an active BOA can compete. Companies that have negotiated a BOA can still participate in ICB, but they would still need individual declarations of eligibilities for projects. Well, Ira, the agency normally conducts about 4 major ICBs per year. There's an average of 57 firms on the bidders list, and we receive about 4 bids per ICB in the Brussels location. Mm-hmm. The agency conducts an average of 9 BOA competitions per year, and each listing on average 110 companies. We receive an average of 4 bids per BOA competition as well. About 96 companies, and that's covering contracts and purchase orders. Due to the fact that the vast majority of NATO member countries are European, it is not surprising that European companies receive the majority of contract awards. However, this should not discourage American firms from submitting bids, as the agency is striving to promote a level playing field, and on any given procurement, American firms have an equal chance of winning contract award. In lowest compliant bidding, obviously a sharp pencil is required, as the initial cut is based on lowest price, followed by a technical determination of compliance. If you do not have the lowest price, your chances of receiving award are fairly slim. This is true of either ICB or BOA competition. ICB based on best value requires a decision on the part of the bidder as to whether to pursue a technically superior proposal or to submit a technically average proposal at an extremely low price. In either case, it should be remembered that price will be a major, but perhaps not a deciding factor. In all cases, attention to detail in the response is critical. The evaluation criteria and bidding instructions are published. In a best value procurement, even the top level weighting factors are disclosed. Read these carefully and respond accordingly. Do not make assumptions. If you do not know what is meant, ask questions. The agency will only evaluate what is written in your proposal, so if you fail to include the required information or tell us what you think we want to hear, you risk being downgraded in the case of best value or declared non-compliant in the case of lowest price technically compliant bidding.